Good afternoon, everyone. Welcome to the Assembly Committee on Commerce and Labor. Madam Secretary, will you please call the roll?
Assemblywoman Carlton. Assemblywoman Considine. Assemblywoman Dickman.
Here.
Assemblywoman Duran. Here. Assemblyman Flores. Present. Assemblyman Frierson. Assemblywoman Hardy. Assemblywoman Kasama. Here. Assemblywoman Martinez. Assemblywoman Marzola. Here. Assemblyman O'Neill. Here. Assemblywoman Tolles. Chair Howdigi.
Here, thank you. And Madam Secretary, if you will mark all other members absent, excused, and please mark them present as they arrive. Welcome everyone who is here with us in person, to everyone who is listening online on the internet, and everyone who is on the telephone line. I would like to give you guys a lay of the land, so that everyone who is here for other bills can excuse themselves if we do not get to them. I will be taking the agenda out of order today. So we will be starting with Assembly Bill 386, followed by, Senate Bill 386, followed by Senate Bill 340, followed by Senate Bill 325. Then we will take the remainder of the Senate bills in numerical order. So Senate Bill 205, 291, and SB 453 last. For those of you who did not make it into the room, we do have an overflow room set up in 3142. Because of the number of bills on our agenda today, I would like to get through as many of them as possible. We will be limiting the bill hearings to 30 minutes per bill. So members, if you have questions, I would encourage you to take them offline and continue the conversations. We will be meeting again possibly tomorrow, so there is time to continue conversations. At this time, I'm going to forego housekeeping. I think everyone knows electronics off. Members use their laptop to view exhibits and bills. It's not a sign of inattention. So I'm going to go ahead and roll right into our bill hearings and open the bill hearing on Senate Bill 386, which revises provisions relating to certain businesses. I believe I have our presenters with us on Zoom.
Thank you. This is Paul Moore with...
Hello, Mr. Moore. I believe, yes, I have you and Ms. D. Taylor to present, correct?
Correct.
Okay, when you're ready, please.
Thank you. Paul Moore with McCracken, Stemmerman, and Holsbury, and here with D. Taylor from the Culinary Union. We're here today with a very important bill, and a bill that's been the product of quite a bit of work in the Senate by the committees and by the Senate, and also between the Culinary and the local Joint Executive Board and the Nevada Resort Association. This is a measure that is quite important for getting Nevada's economy back to work, for getting the many workers who were laid off as a result of the pandemic back to the jobs that they were in before. And it is a law that has been passed in similar forms in many cities and now by the state of California before Nevada. The basic outline of the law is as follows. Workers who in select industries, the industries that have been hit hardest by the pandemic, in the tourism and hospitality and gaming industries, Those who have been laid off as a result of the pandemic and through no fault of their own will have a path back to their jobs. It will require that covered businesses make offers of employment to laid off workers. There's no obligation on the part of covered employers to create work. It simply requires that where they have open positions, they first offer those positions to laid off workers who either were in the same position before they were laid off or were in a similar position before they were laid off. So that's the crux of it. A lot of work has gone into addressing the concerns of industry, particularly in making the requirements as clear as they can be, and in making sure that the rehiring process is not delayed by the obligations that are contained in the bill. And we've done this in a number of ways. We've refined the notice procedures. We've worked with industry to make sure that if someone rejects an offer, that eventually employers don't have to keep making offers to that person. So essentially you get 3 bona fide offers if you're a laid off employee that you can turn down. And at that point, an employer does not need to continue making offers. And we've worked very closely with industry to create an enforcement process that we think works well, under which laid off employees who believe their rights have been violated can either go to court or can take their complaint to the labor commissioner. We think this is a hugely important measure. It's important for the many, many workers who lost their jobs during the pandemic and who are now looking for a way back to the jobs that they've worked for 10, 20, 30 years. And also contained in SB 386 are updates to SB 4 from 2020, which created certain obligations on employers to address the risk of COVID spread. And we have, again, worked with industry to look at ways to revise those obligations to bring them up to date with the most recent CDC and state health guidance. This is a temporary measure. The obligations to recall former laid off workers would last until the rescission of the governor's emergency order or August 31st, 2022, whichever is later. So this is not a permanent bill, but it's a bill that's very important, we believe, for bridging from the pandemic partially closed situation that the economy was in to bringing those who were laid off back to work. I'm going to stop there and see whether Detailer wants to add some comments, and I will remain if there are questions about the bill. We also have Robert Ostrovsky from the Nevada Resort Association, who is with us and with whom we worked quite closely on refining the language in this bill, who's also available to ask questions.
Thank you, Mr. Moore. And at this time, I think we will go to the Majority Leader, Cannizzaro, first for remarks, and then we can go to Mr. Detailer and Mr. Bob Ostrovsky after. And I would just like to remind the presenters that we do have a heavy agenda, so if we could keep our remarks and then go to question and answers. Thank you.
Absolutely, and thank you, Chair Howdicke and members of the Assembly Commerce and Labor Committee. My name is Nicole Cannizzaro. I represent Senate District 6. It is located in the northwest portion of the Las Vegas Valley, and I am pleased to be here today to present to you Senate Bill 386, which provides a pathway towards back to employment, for so many of our workers that we know have been so affected by the pandemic in this last year. I will keep my remarks fairly brief. I can walk through the bill if that pleases the committee and walk through just some of the sections. I know Mr. Moore, it sounded like when I walked in, was walking through a lot of those pieces. Fundamentally, I think what this bill is aiming to do is to say to those workers who have been laid off since the pandemic, who had a job one day and found themselves without a way to provide for their families the next day, a pathway towards getting those jobs back. And that's exactly what this bill is designed to do. I am very thankful for the hard work of the Culinary Union, our resorts partners, the involvement of the governor's office to make sure that I think what we have is something that is that not only makes sense, but also provides some clarity for how this process should work and ensures that those workers who have lost their jobs have a pathway back to that. I obviously grew up in a household where my parents, a bartender and a waitress, worked hard every single day to make sure that we had what we needed in our household. And so for me, I understand some of the plight for those who just simply don't have the means to provide for their family and how important it is to make sure that we can still do that. And I think in the face of a pandemic, it requires us to take action to ensure that that is something that we can promise to workers here in Nevada, especially those who support one of our top industries and help make Nevada the kind of place that people do want to come and visit. This security and this economic security of knowing that they have an opportunity to return to their jobs when business returns, and I think that's an important piece as well, I think is a critical piece and the whole purpose for this legislation. So Chair Howdigi, I can walk the committee through the bill very briefly. Section 4 of Senate Bill 386 in its first reprint provides that the provisions of sections 2 through 28 establish minimum labor standards and does not preempt or prevent employment standards that are more protective and beneficial for employees, nor do these provisions supersede an employee's right to recall pursuant to a collective bargaining agreement. Section 6 through 19 define certain terms applicable to the provisions of this bill. Section 11 defines covered enterprises as an airport hospitality operation, an airport service provider, a casino, an event center, or a hotel that is in a county whose population is 100,000 or more. Section 16 defines a laid-off employee as an employee who was employed by an employer for not less than 6 months during the 12 months immediately preceding March 12, 2020, and whose most recent separation from the employer occurred after March 12, 2020, which was due to a governmental order, lack of business, reduction in force, or other economic non-disciplinary reason. Section 20 requires an employer, in the event of a layoff, to provide an employee who is to be laid off a written notice of the layoff, which must include a notice of the layoff and effective date of such layoff, a summary of the right to reemployment pursuant to sections 2 through 28 of the Act, and contact information for the person who the employer has designated to receive, on behalf of the employer, an aggrieved employee's written notice on alleged violation of the provisions of this bill. The notice must be provided at the same time of layoff. However, if the layoff took place before the effective date of this Act, the employer must provide such notice within 20 days after the effective date of this Act. Section 21 requires employers to retain certain information of an employee. Section 22 requires the employer to offer a laid-off employee each job position which becomes available after the effective date of this Act, and which the laid-off employee is qualified. Section 22 requires employers to offer job positions in an order of preference, beginning with the same or similar position the employee filled at the covered enterprise at the time of the layoff. And the employer is also required to afford a laid-off employee who is offered a position at least 24 hours to accept or decline the offer. And a laid-off employee who is offered a job must be available to return to work within 5 days after accepting the offer. If the laid-off employee does not respond to the offer or is not available to return to work within 5 days, the employer may recall the next available employee with the greatest length of service. An employer who declines to recall a laid-off employee because the employee lacks the qualification and hires another person must, no later than 30 days after making the decision, provide the laid-off employee with a written notice of the decision identifying all the reasons for the decision. Section 23 prohibits an employer from terminating, reducing compensation, refusing to employ, or otherwise take adverse action against a person who takes certain actions in relation to the provisions of this Act. Section 24 authorizes the enforcement of the provisions of this Act by an aggrieved employee through the Labor Commissioner or a civil action in court. Section 24 sets forth certain standards for establishing and rebutting certain presumptions concerning violations of the Act. Section 25 imposes the requirements and duties of the provisions of Sections 2 through 8 inclusive to certain employers who purchase or otherwise acquire another employer that owns or operates a covered enterprise, and extends those rights to laid-off employees of such employers. Section 26 provides that the provisions of Sections 2 through 28 apply to all employees, regardless of whether the employees are represented by a collective bargaining agreement, but does provide that the provisions of this act do not apply to a laid-off employee who is a party to a valid severance agreement. Section 27 prohibits the provisions of Sections 2 through 28 from being construed to invalidate or limit certain other rights, remedies, or procedures. Section 28 provides for the severability of provisions of this act. And Sections 28.1 through 28.5 revise provisions requiring the Director of DHHS and the District Boards of Health to adopt regulations prescribing requirements to reduce and prevent the transmission of the virus that causes COVID-19 in public accommodation facilities. Finally, the bill provides that regulations adopted by the Director and District Boards of Health to reduce and prevent COVID-19 transmission must be amended to reflect the new requirements, and that provisions in these regulations that conflict with this bill are unenforceable. Madam Chair, that does conclude my brief walkthrough of the bill. I know that Mr. Moore had already addressed the committee, and and Mr. Taylor, and I think he mentioned as well, Mr. Ostrowski can answer any questions that the committee may have about this bill.
Thank you, Majority Leader. And so are Mr. Taylor and Mr. Ostrowski just here for questions? Okay, perfect. Thank you. Then at this time, I am going to go to members for questions. Members, do we have any questions for our presenters? I'm going to start with Assemblymember Tolles.
Thank you, Madam Chair, and forgive me. Nice to see you, Majority Leader. And forgive me for I'm looking at a couple different amendments, so I want to make sure I didn't miss anything. I do appreciate that a lot of stakeholders have come together and worked on this and talked through concerns. Was there any kind of employee limit that was added to this where it would impact a company, let's say, that has 50 employees or less differently than a company that has 50 or more employees? Was there any changes to that? Thank you.
Thank you, Assemblywoman, for the question. Through you, Madam Chair, to Assemblywoman Tolles, Nicole Cannizzaro.
You can go direct.
Thank
Majority
you.
Leader.
Nicole Cannizzaro, Senate District 6. No, that was not included in the language of the first reprint.
Can you follow up? Yes. Okay, thank you. And I do appreciate the intent. We have a lot of tenants in Northern Nevada. It's been quite a year, about 120 small businesses in Northern Nevada that we're connected with personally, and just trying to think through how this can impact them. Have you spent time talking with those small businesses, working with chambers, working with those groups to talk through how these provisions might work? These are typically small mom and pop shops. We're not dealing with collective bargaining agreements or what have you. It's just, those tiny retailers and tiny restaurants and nail salons, those kind of places. Just what's the feedback been in regards to how this might impact them? Thanks.
Thank you for the question, Assemblywoman Nicole Cannizzaro, Senate District 6. So I would point to Section 11 for what constitutes a covered enterprise, and certainly would welcome, if Mr. Moore has any additional information he would want to provide in addition to that. But we are not talking about every business throughout the state of Nevada. It is designed to get at those hospitality-type businesses that are included. And so we've obviously had a lot of conversations about some of the more impacted businesses that would face some of these provisions. But I think some of the smaller businesses that you might just be thinking of wouldn't fall under the provisions of this bill.
Follow up. So not the small retailer or the small nail salon, but maybe more the small like restaurant or bar would still. And I'll go back and look. And I do apologize. I have a couple amendments in front of me, so I just wanted to make sure I was looking at the right one. Section 11. But so smaller restaurants and bars might fall into this within that hospitality definition.
Thank you, Assemblywoman, for the question. Nicole Cannizzaro, Senate District 6. So in Section 11, a covered enterprise is defined as an airport hospitality operation, an airport service provider, a casino, an event center, or a hotel that is located in a county whose population is 100,000 or more. That would limit a lot of the places that I think that you may have referenced. Certainly, I think there are some smaller pieces that may operate under those facilities, but definitely is not wholesale some of the places that you have mentioned.
Thank you.
Members, any other questions? Okay, I have a question, Majority Leader, but I believe there was actually remarks that were part of the presentation that I skipped. So at this time, I do want to go to Mr. Ostrowski.
Yes, thank you, Madam Chairperson, members of the committee. Bob Ostrowski on behalf of the Nevada Resort Association. We started out opposed to this legislation in the Senate. Through some really good faith negotiations, we've been able to move our position off of that. We are now officially neutral on a majority vote of the board of the Resort Association. So that should be clear on the record. We had 350,000 employees in the hospitality industry in February of 2020. By April of 2020 was less than 200,000, so it was greatly impacted. Our association has 77 members out of 175 plus unrestricted casino licenses in the state. So we represent just not quite a majority of those, but certainly the larger properties. And we just wanted to express the fact that we appreciate working with the members of the negotiating side on behalf of the Culinary Union, and to the distance in which they moved from the original language. It's a bill that we've decided we can live with, but we can't support and have pledged not to take a position in opposition to that, and leave it as a policy matter for the legislature. It is, however, very important for us to understand that the sections involving SB 4 from the special session are included in here, and the record should be clear that is the intent that section 28.1 to 28.3 inclusive and 28.5 of this act to follow the same expiration dates that were adopted in SB 4, Section 4 of the 2020 special session. We discussed this with the advocates of this bill. They're in agreement with that. So there's no confusion about the difference between SB 4 and this bill. And we clarify that those sections become effective on June 1. That's 28.1 to 28.3. And Section 28.5 does not authorize the Department of Health and Human Services or local health district to make further amendments to provisions of these sections as stated by the majority leader. And I'm available to answer any questions. Thank you.
Thank you, Mr. Ostrowski. And that was actually perfect timing because that kind of leads me into the question I had. And it's probably going to be for our legal counsel, if that's okay, Mr. Quast, because I know that during the summer we did pass SB 4 and Section 4 is now NRS. And so I had similar questions that SB 386 isn't in conflict, isn't the intent of SB 386 is consistent with SB 4, and specifically the sections that Mr. Ostrowski was referencing, Section 28, 1, 2, and 3.
Thank you, Madam Chair. Sam Quast, Committee Counsel. That's correct. NRS 447.325 sets forth certain periods in which the provisions of that you're referring to in SB 4, the provisions of NRS 447.300 to 447.355, the periods in which those apply. Sections 28.1 to 28.3 amend sections within those sections, and so they would also apply within the periods prescribed in 447.325.
Thank you, Mr. Quast. I appreciate that. And seeing there's no further questions from the committee, before we go to testimony, Mr. Taylor, did you have remarks?
Yes. Thank you, Madam Chair. Dee Taylor from United Here International Union. I want to applaud and thank both the Nevada Resort Association. I also want to obviously recognize Speaker Canizario and her work on this. And I want to put this in perspective in one way. The exact same workers who before the pandemic were praised as the most important asset of a company should not be viewed and discarded like a pair of old shoes because of the pandemic. And this is not a union or non-union issue at all. This is a basic worker issue that allows people to get back on their feet and get back to work. When employers complain they can't find workers, and at the same time they say, we don't want to bring back any of our other workers that we had previously, I find that just to be a contradiction that cannot live. And so we're very, very hopeful and appreciative, if the Assembly can see through, to pass this measure, to give people the right to go back to their jobs they lost for no other reason besides the pandemic. And I want to thank, like I said, all the work that's been done by the Nevada Resort Association. I want to recognize the work that the Senate has done, and I would like to have this go forward so workers don't have the double hit of both losing their job because of the pandemic, and in many cases, 20 or 30 years out of place, that they would be discarded, like, as I said, a pair of shoes and not be able to go back to work. So I appreciate it. Thank you, and be open to any questions that are asked.
Thank you, Mr. Taylor. And it looks like we did have a question that I overlooked. Assemblymember Kasama?
Thank you, Chair, and thank you to the presenters. My question was to Mr. Ostrowski, I believe the name is. So I believe you said the Resort Association was employing in February 350,000. It dropped to 220,000. Do you know what is the number that is employed currently?
This for the record, Bob Ostrowski. To you through the chair. I don't know the exact number. We were at 350. That's not just the association. That's a industry-wide number. My expectation is that when this is all over, about 70% of the employees who were working for us back in February of 2020 will return to their jobs. Some 30% will, through normal, regular turnover, they moved, they found another job they want more than the one they had. We'll have to be filling those jobs from those people who are new applicants. And of course, we have new competitive casinos opening on the Strip. So I can't give you a good hard number, but I'm guessing it's closer to 275 to 300,000 now. We've got a ways to go, but tourism is accelerating at a very high rate. Conventions are beginning to return, and we're very hopeful that by the time the next convention season rolls around, we'll be back to full employment, if not sooner. Thank you.
Follow-up, Chair?
Go ahead.
We all hope that we are fully not only back to normal, but above. And I know we're all wishing for that. And thank you. I know that's kind of a hard question for me to ask you on the spot. My question kind of goes along with that, though. So if we've lost so many people and we're ramping up again, we're hiring, and what happens if we've already employers at this point have hired, and I don't know if they've already reached out to people that were laid off, if they've done that first or not, but let's say a lot of these positions have been filled now, and now the employees that were laid off that haven't been offered that position come and want it, but they don't have the room for it. How is that being handled in this bill?
For the record, again, Bob Ostrowski, the question from the Assemblywoman. This bill only applies to vacancies that occur on and after this act becomes law. So if positions have been filled along the way, either through recall or hires, those people will not be impacted. So if you have your job now, this bill doesn't require us to create a position or to lay off or terminate any other employee. This will go for future vacancies, and the thought, the negotiations over a period of time, there will be enough vacancies to recall.
So it wouldn't be a requirement.
If I'm wrong, Paul can jump in.
You're right.
So it wouldn't be a requirement to hire more people than you need because you've already hired some people already? I'm trying to figure out, a lot of the casinos have already been hiring a lot of people to ramp up. And so then if this bill goes through and it says you have to offer that to everybody, but there's no longer a position for them, will the casinos be required to hire them even though they don't have a need? That's what I'm trying to understand.
For the record, Bob Ostrowski, the answer is clearly no. We're not required to create any positions. I know you've been reading in the newspaper that we've had hiring fairs for certain jobs, and we're heavily recruiting. We'll go back again through our recall list to make sure that if people have seniority, they're going to get notified under the Act, and they'll get recalled under the Act. We are not required to create a position. We're not required to overstaff in any way as a result of this bill.
Thank you. Okay, so at this time, we are going to go. Oh, I'm going to go to our next question, Vice Chair Carlton.
Thank you very much, Madam Chair and Mr. Ostrowski. Mr. Taylor, it's very nice to see you. So, Mr. Ostrowski, you just mentioned the question that I had, and I wanted you to reiterate that. You had mentioned the word seniority. So, no matter how it's looked at, if a waitress had been at Treasure Island for 15 years and another one had been there 7, that one that had been there for 15 years would get the first call, and you would work down that seniority list. I just want to make sure that we're clear on that, because that's, if you've given that many years to your employer, you should get that consideration first. So you had mentioned seniority, if you could expand on that.
Yeah, for the record again, Bob Ostrowski to Assemblywoman Carlton. Yes, the most senior employee will get the benefit of the first recall. Under the provisions of this bill, they actually get 3 opportunities at recall. There's a requirement here that we recall, the person can turn the job down for whatever reason or no reason. After 3 weeks, we could recall them a second time until they, a third time, been recalled and said they did not want to return. We will continue to contact that person through 3 rounds of recalls on a strict seniority basis.
Thank you very much, Mr. Ostrowski.
Okay, sorry, I opened it up for remarks and the questions just started coming in. So we do have another one from Assemblymember Dickman. So, Ms. Dickman?
Thank you so much, Chair, and this will be quick. But so if this bill did not pass, you would not follow these procedures and recall former employees back to their jobs, even though there's such a shortage of employees available? I guess that's for Mr. Ostrowski.
For the record, Bob Ostrowski, to Assemblywoman Dickman. Each of our properties is a little differently situated. Some of our properties have collective bargaining agreements. Those agreements had specific recall procedures in the event of a layoff. Some of those agreements have actually been extended by our members so that those recall rights have been extended beyond what was normally about 12 months. Some have extended them to 24 months. Those have been separate and private negotiations under the current terms of their collective bargaining agreements. Some of our operations are non-union and have various policies in place for recall. And so they've applied those policies. This bill, as drafted, would overlay a new set of rules that all of the properties would have to go by and benefit. I think Section 4 indicates in this bill that if you have a collective bargaining agreement and you have benefits which are greater than contained in this bill, the collective bargaining agreement would apply. If your agreement doesn't have the same benefits that this bill offered, then this bill would apply. I think, Mr. Moore, if you want to comment on that, I think that was the intent of Section 4. I hope that answers your question.
Yes, Paul Moore for the record to the Assemblywoman. Yes, we, because collective bargaining agreements frequently have recall provisions, and those are frequently provisions that are both offer greater protection and are part of complicated systems for recall. We have included a provision in Section 4 that makes clear that if there's a conflict between the collective bargaining agreements, recall procedures, and what's in this bill, that the collective bargaining procedures would be followed by the employer. We expect, and we know that many employers will be bringing back their long-term employees. And so this bill is there for what we hope is the outliers, and to create a floor so that everyone is following the same rules. Many of the employers, as Mr. Ostrovsky was saying, covered by this bill have already made commitments to bring back their experienced workforce. So this is setting a minimum standard for union and non-union properties in the covered counties so that they're on a level playing field.
Thank you for that, and thank you, Madam Chair.
Yeah, and just, Madam Chair, for the record, Bob Ostrowski again, I just want to make sure that I didn't misstate that. As Section 4 says, the collective bargaining agreement is going to be looked at first and clearly. So the collective bargaining agreements that I've signed will be the prevailing document. Thank you.
Thank you. Okay, at this time, we can now move into the testimony portion of the bill hearing. We are going to start with testimony and support in Carson City. Members, because of the number of bills on our agenda today, I will remind you I am going to enforce the 2-minute per speaker rule so we can hear from as many people as possible. I will be limiting testimony as well in support, neutral, and opposition. So anyone here in Carson City wishing to testify in support of Senate Bill 386, please make your way to the table.
Thank you, Madam Chair, members of the committee. For the record, Rusty McAllister, representing Nevada State AFL-CIO. We are in support of this legislation. We believe it's the right thing to do. This is not just a union bill. This is a union and non-union worker. And it doesn't just affect people from the culinary union. I know that gets mentioned a lot, but workers for the United Auto Workers who represent dealers in the hotels, from the IATSE, all the stage shows have been shut down. So all the stagehands that work those shows have been laid off. This is Teamsters that set up conventions and do work like that, along with operating engineers who do the heating and air conditioning and service work in the buildings. So this is covers a wide range of employees throughout the state. And so for those reasons, we are in support of this bill. Thank you, Madam Chair.
Thank you, Mr. McAllister.
Thank you, Madam Chair. My name is Marlene Lockhart, L-O-C-K-A-R-D, representing SEIU 1107. We are in support of this bill. We recognize what a horrendous year 2020 was for workers in our state, and we appreciate the parties coming together to develop a path for workers to return and provide some certainty again in their lives. Thank you.
Thank you, Ms. Lockhart.
Madam Chair, Chris Daly, Nevada State Education Association. NSCA supports SB 386, giving thousands of unemployed workers in Nevada the right to return to their jobs. The Culinary Union is an important labor partner of NSCA, and we've worked closely together during the COVID-19 pandemic. We appreciate the tens of thousands of students in our schools have parents in the hospitality industry who have unfortunately had their lives upended by the COVID-19 pandemic. The safe reopening of school buildings was only one part of getting our students through to the other side of this pandemic. The ability of their parents to return to their jobs would provide the economic stability necessary for students to be able to arrive at school truly ready to learn. Educators know this is too often not the case when students struggle at home with issues of food insecurity, housing instability, and parents facing the stresses of unemployment and not being able to provide for their family. SB 386 is the right thing to do for labor. It will also help thousands of Nevada students and their families. Thank you.
Thank you, Mr. Daly.
Madam Chair and members of the committee, for the record, my name is Annette Magnus, and I'm the Executive Director of Battleborn Progress, and we are here today in strong support of SB 386. My neighbor, close friends, and many of our advocates were part of the massive layoffs in last March, all culinary workers. Their lives were turned upside down. Many of them couldn't pay their rent, their mortgages, and were struggling to put food on the table. Once hotels and casinos started reopening, they hoped they could safely return to work. Some did, and some did not. That's what many workers still want to do, but they haven't been called back to work. Do you know how heartbreaking it is to be laid off from work you have done for decades and not be called back, but your employer is holding job fairs to hire hundreds of new employees? This shouldn't be happening. People who are desperate deserve the right to return to their previous jobs. Please pass SB 386. Nevadans are desperate for your help. Thank you.
Thank you, Ms. Magnus.
Good afternoon, Chair and members of the committee. For the record, my name is Christine Saunders, and I'm the Policy Director with the Progressive Leadership Alliance in Nevada, here in support of Senate Bill 386. Nevada's workers are what keep our state running, and if we want our state's economy to thrive, we must allow people to return to their jobs, which they lost through no fault of their own, and we urge your support of this bill. Thank you.
Thank you, Ms. Saunders.
Good afternoon, Chair and members of the committee. My name is Jillian Block, and I'm representing the Legal Aid Center of Southern Nevada. The Legal Aid Center of Southern Nevada operates the Legal Service Fund, which provides legal assistance to the more than 60,000 culinary and bartenders union members who are the heart of the Nevada hospitality industry. After the shutdown last year, 98% of these workers became unemployed through no fault of their own, and many remain fully or partially unemployed to this day. Unemployment is the root cause of many issues that have a negative effect on our economy and the lives of Nevadans, including foreclosures, evictions, car repossession, debt collection, bankruptcy, and more. SB 386 will ensure that these qualified and well-established employees will have a right to return to their jobs, which will in turn improve our economy. Thank you.
Thank you, Ms. Block.
Thank you for the opportunity to speak. Benjamin Challenor, on behalf of Faith in Action Nevada. We are a nonpartisan multi-faith organization that organizes and advocates, as well as an inclusive democracy. It is the moral thing to do to make sure that we are getting these workers back to work, to their jobs, in order to make sure that we are having a proper recovery from this pandemic. Thank you.
Thank you, Mr. Challenor.
Kent Irvin, Nevada Faculty Alliance. Many of our students support themselves or their families to get through school in the hospitality industry, and for all the reasons already stated, we support the bill. Thank you.
Thank you, Mr. Irvin.
Good afternoon, Chair, members of the committee. My name is Fran Alvarez. I am here today in support of this bill. I represent Teamsters Local 986. We have many people working the front desk and valet at these hotels, and some of the hotels have already started hiring other people before calling our members back to work. The MGM has outsourced the valet services, and presently at the Flamingo, they have started hiring people who were previously working at the Rio because the Rio hadn't opened yet. Our members are out of work. They would really like to have their jobs back, and I urge you, please vote yes on this bill. Thank you.
Thank you, Ms. Alvarez.
Good afternoon, Chair, members of the committee. Priscilla Maloney with the ASME 4041 retirees. We too are here in support of our brothers and sisters, not just unionized folks, but all working folks here in Nevada. We were particularly distressed to hear that a lot of what the situation was older workers being forced out of their jobs, not allowed to return, folks who had spent over, decades in their positions. So we are in support of Senate Bill 386 and hope you will give it your full consideration this afternoon. Thank you.
Thank you. Is there anyone else here in Carson City wishing to testify in support? Okay, is there anyone on Zoom wishing to testify in support? Okay, broadcasting, could we go to the telephone line?
Testify in support of Senate Bill 386. Please press star 9 now to take your place in the queue. Caller with the last 3 digits of 459. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Thank you. For the record, my name is Jerry Burton. It's Jeriburton. I'm the president of the Nevada chapter of the National Organization for Women. And I'm also a native Nevadan, and I'm here to represent our members in support of SB 386. We know Nevada was one of the hardest hit in the pandemic, and people lost their jobs through no fault of their own. And women have been affected in particular as they make up a very large number of the employees in the hospitality business. So it's fair to bring back workers at the pay and benefits they've earned, and we ask that you vote yes on SB 386 and support our Nevada workers. Thank you.
Thank you, Ms. Burton. Broadcasting, next caller.
Caller with the last three digits of 079. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin. Caller with the last three digits of 079. You are unmuted on our end. Please make sure to double check your phone that you are not muted on your end. Chair, it seems that we're having trouble with this caller. Would you like me to move on?
Yes, please. And to the callers, if we do not get to you or you are not able to share your testimony for time reasons, I encourage everyone to submit their written testimony for inclusion in the meeting record. BPS, if we could take the next caller.
Yes, Chair. If you recently joined the call and would like to testify in support of Senate Bill 386, please press *9 now to take your place in the queue. Chair, there are no more callers in support at this time.
Thank you, broadcast. Now we will go to testimony in opposition. Is there anyone here in Carson City wishing to testify in opposition?
Good afternoon, Chair. Paul Moratkin with the Vegas Chamber. The last year has been challenging for all Nevadans, and we all want to move forward and rebuild our state's economy together. I do believe that's a common goal for all of us. We appreciate the extensive work and the progress that has been made on this bill between the proponents and the industry and the compromise version you see today. We recognize that it's taken a lot of good faith to come together on the version you see today in front of you. Our concerns about the small, locally owned independent business that is not owned by the hotel properties or nationally owned corporations that happen to be located on the hotel property through a lease that may be unintentionally impacted. Again, we appreciate the work that has been done in SB 386 for today, and thank you for your time.
Thank you, Mr. Moratkin.
Madam Chair, members of the committee, for the record, Randy Thompson, State Director for the National Federation of Independent Business. Assemblywoman Tolles brought up some of the concerns that we have. Forever Heather is located in the Reno Airport. It's a small business that is not fully staffed. They would be impacted by this bill. They have not been able to fully staff because the airport's not fully staffed. There's a lot of small independent businesses in casinos, in the event centers, in the airports that will be affected by this bill, and for that reason we oppose it. Thank you.
Thank you.
Good afternoon, Chair Hadagi and members of the committee. For the record, Mindy Elliott, representing the Reno Sparks Chamber of Commerce. Mr. Moratkin and Ms. Thompson both eloquently stated the concerns that we have. It's not the large casinos, it's the small businesses that have been struggling. They've been struggling to keep their doors open. They were shut down too. They've been struggling to pay their bills. And now we have a bill that's going to require them to go back and try to figure out what is happening with some of their employees. And frankly, some of these are really small mom and pops. And to have, and many of them are families that the employees, they become family members because they've worked with them for so long. It's just very difficult, and we're hoping that we understand that the bill and the merits of the bill and what, from the large casinos perspective and the large entertainment industries and the resorts, but for the small mom and pops that just happen to be located under the umbrella in the casinos, we would really appreciate some consideration as it relates to those individuals. And we have a small business definition that's already been drafted into statute. It'd be nice if this would be applicable to this bill as well. For that reason, we stand in opposition. Thank you.
Thank you. Is there anyone else in Carson City wishing to testify in opposition? Is there anyone on Zoom? Broadcasting, if we could go to the telephone line, please.
To testify in opposition of Senate Bill 386, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 425. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
My name is Shelley Stewart. I am not in opposition of 386. I'm on the wrong side. So,
Thank you, Ms. Stewart. Broadcasting, if we could go to the next caller.
Caller with the last 3 digits of 114. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Thank you. Greetings, Chair Hadegay, members of the committee. Amber Stidham for the Henderson Chamber. We too can appreciate the bill intent and all the work that has gone into the most recent amendment to address the concerns of some of the large casino gaming properties and their providers. But also, we too continue to be deeply concerned about the impact this bill has to small businesses that do not fit within that collective bargaining measures and do not fit with within the covered enterprise provisions outlined within Section 11 of the bill. These are businesses like our local and small event and banquet centers, independently owned small casinos, restaurants, local tour operators. These are businesses that are too small, that have limited capacity to meet the provisions outlined within this bill without incurring extremely significant expenses and liability as a result of these efforts, many of which these small businesses have already without meeting legislation. We too would have to urge that consideration is provided for a small business exemption. Thank you.
Thank you, Ms. Stidham. Broadcasting, next caller.
Caller with the last 3 digits of 300. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
My name is Barry Lieberman, Lieberman. I represent the South Point Hotel and Casino. When the global pandemic resulted in the Nevada Gaming Control Board ordering the closure of the gaming areas at the South Point Hotel and Casino on March 17th, an event that had never taken place in the long history of gaming in Nevada, the South Point had no idea when we would be able to welcome back our guests and return employees to work. However, Michael Gaughan, the managing member of the South Point, chose to keep virtually all of the South Point's regular employees on the payroll through the first month and a half of the closure. When the South Point was finally financially forced to furlough some employees in early May, Mr. Gaughan made the decision to continue to pay the very costly health insurance premiums so that the furloughed employees could continue. This is not...
And sir, if you would do me a favor, could you restate your name for the record?
Barry Lieberman.
Could you spell that for us, please?
Lieberman.
Lieberman. Okay, thank you so much. Broadcasting, next caller.
Chair, there are no more callers in opposition at this time.
Okay, thank you. Is there anyone here in Carson City wishing to testify in neutral? Is there anyone on Zoom? Okay, broadcasting, could we go to the telephone line?
To testify in neutral on Senate Bill 386, please press star 9 now to take your place in the queue. Chair, there are no callers for neutral at this time.
Okay, thank you. At this time, I'd like to call our bill sponsor up for any closing remarks if she has any. Okay, then I will close the hearing now on Senate Bill 386. Okay, members, if you could stand at ease for 1 second. Okay, members, at this time, I would like to go ahead and move us into a work session on Senate Bill 386. I am going to hand it over to our policy analyst, Ms. Pasloff-Thomas, to walk us through the work session.
Thank you, Madam Chair. Senate Bill 386 relates to employment and the declaration of emergency for COVID-19. It is sponsored by Senator Cannizzaro, and it was heard today in committee. There are no proposed amendments.
Okay, members, actually, if we could stand in recess for 1 minute. Thank you, everyone, for your patience. We're just waiting for our speaker to join us. All right, members, we will come back out of our recess, and if the committee secretary would indicate that Speaker Frierson has joined us. Thank you. And Ms. Pasloff-Thomas, I think did we finish reading through the work session opening? Oh, no, I think we're good. We just heard the bill. So, okay, members, at this time, I will ask if you have any questions on the bill before you. Seeing none, I would entertain a motion to do pass. So moved. I have a first by Vice Chair Carlton. Have a second by Assemblymember Flores. Any discussion on the motion? Madam Chair, I have to. Vice Chair Carlton.
Thank you, Madam Chair. I just have to say something. These are the folks that I've worked next to for most of my career, and when you can find a good waitress job and be able to work a decent shift, know that you can go home and take care of your family, be the Sunday school teacher, be the Girl Scout leader, be the Cub Scout leader, do all those other things. We're part of the community. The people that we're talking about protecting in this bill are the people that built this state. They are the economic engine of the state. They have given their lives. And I know a lot of the waitresses that I worked with and myself, when we get a little bit older, the knees that we took advantage of and the shoulders that we took advantage of, we all get sore and tired. But, we love our jobs, and I'll tell you what, I know these folks want to do nothing but go back to work. When I talk to them at the food pantry, because they are coming to food pantries, they are looking for rental and utility assistance in food, they want nothing more to go back to work. And I think this legislation will give them the peace of mind of knowing that they will get that phone call and they'll be able to go back to work every day and do the thing that they love to do next to their coworkers every day. So thank you, Madam Chair.
Thank you, Vice Chair. Assemblymember Tolles.
Thank you so much, Chair, and thanks for those comments. And
appreciate the, what we're trying to do to help everyone out. This has been, again, just a brutal year, but I was waiting with bated breath during that little pause to see if there was possibly going to be an amendment addressing some of the concerns of the small businesses, but also knowing that not all the members voted in favor. Also for larger ones, I still share some of their concerns as well, so I will be a no. Thanks.
Thank you, Assemblymember Tolles. Any other discussion on the motion? Assemblymember O'Neill.
Thank you, Chair, for the time. Now, I fully agree with Ms. Carlton's position, and I want to support, and I do believe all the employees should have a right to come back to work. I guess maybe I don't understand Las Vegas economy right now, because up here in the northern part, I've got hospitality centers calling me up, asking me to find employees, construction workers. I actually, admittedly for the fun of it yesterday, filled out an application for a heavy equipment operator without any experience and was hired. They'll train me. I turned it down. But I do think there's been a real strong examples given or needs given to exempt the smaller businesses. And I would like to work towards that. I'd love to see an amendment to exempt those smaller, under 50 or less, even under 20, 30 employee operations. So with that, unfortunately, I just can't get to a yes. Thank you, Chair.
Assemblymember Marzola.
Thank you, Madam Chair. Just really quickly, I just want to say thank you for bringing this bill. We've had a lot of talk today about small businesses. I own my own small business. I had just opened, and then all of a sudden, COVID hit. It was really tough. I almost had to close down. But this bill is for the good of the people. This bill is for the good of Nevada. And if positions in my firm come open, I need to give it back to the people that helped me build it in the first place. And so I just wanted to make that statement because I know, the mom and pop, and that's what I consider myself because obviously, I have a very small business. So I just wanted to get that on the record. Thank you.
And I'm going to take a point of privilege as the chair to make a quick comment, but we have heard a lot of discussions this session about the economic driver and the economic engine of our state and doing what we can to make sure that we are going to have a thriving tourist economy to help our state pull out of this. And let's not forget that that engine is made up of many, many pieces, and the most important pieces to that engine are the employees who go to work there every day and invite the tourists to our state to make sure that they keep coming back to the over 40 million visitors who visit our state a year. Members, any other discussion? Okay, seeing none. At this time, all those in favor, please signify by saying aye. Aye. Opposed? Will the nays please raise their hand? I have Assemblymember O'Neill as a nay, Assemblymember Kasama as a nay, Assemblymember Hardy as a nay, Assemblymember Tolles as a nay, and Assemblymember Dickman as a nay. Motion carries. I will assign that floor statement to Vice Chair Carlton. Okay, members, at this time, we will go back into the bill hearing portion of our agenda. And next on our agenda is Senate Bill 340. So I will open the hearing on Senate Bill 340, which revises provisions relating to the wages and working conditions of certain employees. I believe we have Senator Neal here with us to present. And Senator Neal, I also show that we have a Matthew McDonald presenting with us. Is he on Zoom?
Yes, ma'am.
Okay, thank you. Mr. McDonald, if you are with us, if you would please just turn on your camera so that we can see you. When you're ready, Senator.
Thank you, Madam Chair, and good afternoon, Assembly, Commerce, and Labor. I am Senator Dina Neal, representing Senate District 4, here to actually co-present SB 340. I just want to give some quick opening remarks. I think every time I've testified on this bill, which I think is twice now, I have a different story or different memory. When I was asked to bring this bill, I was sitting in the hospital actually waiting on my dad, and he wasn't even at the stage where I needed to get personal home care health. But I ended up having a direct relationship to this bill, not knowing that when I was asked to carry it, that I would have that relationship. I ended up my family having to hire a personal care attendant to come in and help take care of my father while he was recovering when he left Dignity Health. And that I had a chance to meet a small business. It was owned by a black woman, and we interviewed her, and then we found out that there was a range, so we could pay $15 or we could pay the max, which was $22 an hour. And so I selected to pay $22 an hour to have a woman come in roughly 3 hours a day. I guess it was 15 hours a week to come in and help us, because it was me and my daughter, and then she would help come in and help bathe him, get him ready, get his pajamas on while he was in a hospital bed. And when I came into session and I realized that SB 340 was going to give a voice to the woman that I encountered and the other workers, men and women, who do this work, it became a bill that became personal for me, because I understood the level of work that they do and the level of impact that they have upon families. It is a big deal to have a home care worker to be able to come in and help you offset some of the duties that you have and responsibilities you have to take care of a family member that is sick, that cannot take care of themselves. And when we talk about proper wage and having a seat at the table and being a part of a board where they can discuss their relationship with their employer, this bill sets that up. I had a different experience where I was dealing with the direct employer and her employee. And on the days when her employee, Miss Tina, could not come, her boss would actually come in and fill in for that time. That's how small of a business it was. She had probably 4 personal home care workers. And so I wanted to put that on the record, because I read, I don't know if it's 26 letters of opposition, but when I read the different letters and the comments pretty much kind of reiterated the same comment that this bill was somehow an assault on the employers and somehow an assault on their model, I disagree. I disagree for several reasons, because this bill should be seen more of a balancing measure between employer and employee, and allowing actual personal home caregivers to actually have a seat at the table when there is a wage issue, when there is a discussion about the hours that they've worked. And this bill does that. It gives not volunteers power, but it actually gives workers power, and then it is a relationship that is then developed within Health and Human Services, because the director, when you read the bill, has roles and duties that are attributed to this board. And so I just wanted to put that out there as my opening comments, because it's not an assault on these employers. It's a balancing bill that gives a right and opportunity to the workers that serve those families and share households with them for hours out of a week. And I think that they deserve a seat at the table to discuss the issues that affect them where they did not have that. And so I will then turn it over to Ms. Lockhart, and then I believe it's another person will go through the bill, but I'm here to also help and assist in that. Thank you.
Thank you, Senator. Ms. Lockhart?
Thank you, Madam Chair and members of the committee. My name is Marlene Lockhart, L-O-C-K-A-R-D, representing SEIU 1107, the largest movement of healthcare and public workers in Nevada, approximately 19,000 strong. Last fall, the Gwynn Center issued an assessment of the personal care workforce in Nevada, reporting that a dire crisis is on the horizon, creating a dangerous home care worker shortage, which will hurt Nevada seniors, people with disabilities, and home care workers alike. Nevada has approximately 13,000 home care workers, and the Gwynn Center report projects we will need to add some 5,500 more to the workforce by 2026. To compound an already simmering public policy time bomb, the Elders Count report indicates Nevada has been and will continue to experience an aging tsunami. Nevada's population has increased by almost 11.5%, while the 65 and older population has increased by a whopping 40%. Nevada's growth rate for the age 85 and older is double the national rate. 1 in 2 home care workers leave the job within a year of taking it, while the need to attract and retain a dedicated home care workforce is clearly established. It is also clear that Nevada does not currently have policies in place to accomplish this. SB 340 will establish the Nevada Home Care Workforce Safety and Standards Act, which will create a board made up of workers, consumers, employers, and state officials to recommend improvements based on examinations of training, COVID-19 protocols, protective equipment, benefits, and other issues in order to retain these essential workers. This board will bring the voice of all parties to the table to coordinate for the first time the development of consistent standards, best practices, and to establish a stable, long-term, and committed workforce recognizing home care as an undervalued yet critically important profession. SB 340 will save the state money. According to expenditure data provided to CMS, the state estimates an average per capita savings of over $70,000 per year when a senior is served through the Medicaid waiver program instead of a nursing facility. Those of us who care for loved ones know our families want to stay in their homes as long as possible. Sadly, COVID-19 has exposed the risks and safety issues existing in many institutional care facilities. We believe that investing now will pay multiple dividends to the state by saving millions of dollars in millions of future dollars that will be expended if we do not act. And you do too. This body and the governor issued the Every Nevadan Recovery Framework. As expressed in this document, you and the governor have shown your foresight into the strategy needed to stave off the consequences of ignoring the alarm bells our policy experts have sounded. This is the time to act to ensure the safety and protection of our seniors, the disabled, and to improve the lives of our essential home care workers, which they richly deserve. Madam Chair, we have Mr. McDonald on the line to answer questions. I am, however, prepared to walk through the bill if you choose to have me do so.
I think, was Mr. McDonald going to give remarks or just answer questions? Because I think in order to...
Just answer questions if needed.
Okay, perfect. If you would just give a high-level overview of the bill, Ms. Lockhart, and then we can move quickly into question and answers and then testimony.
Sure. The home care workforce is designed as any caregiver providing publicly funded personal care, personal assistance, or temporary respite care who is employed by an agency contracted with aging disability divisions. Convening the board is triggered by at least 50 home care workers filing a petition with the Director of Hhs, or if the director determines the board, or if the director determines the board's convening, if necessary. Before the board's first meeting, the HHS director and labor commissioner shall collect relevant data on the wages, working conditions, and compliance with relevant laws within the industry and share their findings with board members. The composition of the board will consist of the HHS director or his designee. The board members would consist of the labor commissioners, 3 representatives of home care health workers, 3 representatives of home health care employers, and 3 representatives of home care consumers. Members serve on a voluntary basis, and meaning they would receive no compensation for serving on the board. Topics to be investigated would be the wages paid to home care workers, safe and healthful working conditions. The bill does not prescribe the exact topics that must be investigated. Instead, it lays out a list of topics for the board to consider. Those topics include reimbursement rates, wages, training, recruitment, retention levels, and worker protections. The board recommends any recommendations supported by at least half of the board members would be included in the board's final report, which is due no later than 1 year after the board's first meeting and will be released online. Implementation, the Human Services Director will decide which recommendations to effectuate via issuing regulations, subject to legislative and federal approval where applicable. And the Director may also disapprove of any board recommendations and may recommit the subjects to the same or a new board. The Labor Commissioner shall have the authority to enforce all recommendations that the HHS Director has implemented, and the Labor Commissioner shall also enforce employee protections to prevent an employer from discharging or threatening to discharge an employee based on their participation in the board process. Lastly, the board is charged with developing recommendations relating to COVID-19 safety protocols, including the distribution of PPE, effective training, outbreak reporting, vaccine distribution equity, and the disbursement of federal relief funds. These recommendations shall be shared with the governor and the legislature.
Okay, members, do we have questions for our presenters? I'm going to start with Assemblymember Tolles, and we'll move on from there.
Thank you, Chair. I appreciate the indulgence, and thank you. It's good to see you. And I just want to acknowledge the home care workers in this room. Similar to Senator Neal, I had my father-in-law. We got the privilege of taking care of him and all the way through hospice and the end of his life. And I couldn't say enough about the home care workers that we had who helped us through those last years. Just unbelievable. God's work, for sure. And I appreciate the conversations around this bill. Particularly, I appreciate the membership of the board with really bringing together collaboration and that balance of the employers and the employees and then, representatives and so forth. And I appreciate the training aspect and the, publishing those things on an internet website. I think all of that for compliance is really beneficial and helpful overall to everyone involved. My questions have to do with sections 18 and 19. So as I read it, one of the tasks that would come out of this board would be to give authority to come up with recommendations regarding wages and then conditions. And then if those recommendations are adopted, then every employer with home health care workers, whether they're engaged in this board or not, would be under the provisions of having to comply with those new wage and conditions. So in other words, it's not something that's put in statute, it's a new layer. Is that how I'm reading it?
The director of HHS would adopt regulations, but all of it is subject to the approval of state and federal regulations. So the wage aspect, other approval items would come back to the legislature if it is outside of his statutory authority. Thank you.
So, okay, so it's not that we would have, this board would be establishing a new minimum wage or new work conditions. It would be, they would make recommendations and then the legislature would then consider that?
The some of the authority of the HHS director is to establish recommendations on training and other aspects. So if it's within his authority, but on the wage component, it would be within the approval and purview of this body.
Right, okay, because that, forgive me, I'm sorry.
Follow up?
Appreciate the ability to go back and forth with that. So that is how I read it under section 19, that any home care employee for a wage less than that established by regulation of the director. Yeah, so that would be, so follow up, Chair, please? Yes. Thank you. So we've had conversations before because this body has passed changes to minimum wage, and there's been questions and conversations about what happens with that combined with our overtime laws, how that prices us out of Medicaid reimbursement, and the concern there that Senator Neal and myself were able to provide that for our loved one, but would we inadvertently price out a family from being able to afford that because we've gone beyond the Medicaid reimbursement rate? That would be the concern that we've had in this body before. Thank you.
Thank you. It is anticipated that increasing the Medicaid reimbursement rate would be fully investigated and recommendations made in that arena as well, because that is a critical problem for the healthcare worker in the state of Nevada. And I would turn to Mr. McDonald if he has any further comment on that or to correct me on anything I may have stated.
No such corrections. I think that the board will have to examine how prices are set in the private pay market. I think that there is, no distinct methodology to that, and rising Medicaid reimbursement rates in this case, I think, would overall create better outcomes for consumers and workers without impacting the demand that will be placed on these services. That's one thing that I think all studies indicate, is that the demand for these services is growing dramatically. And raising wage rates is a critical component of making sure that workforce is available to consumers who will need those services in the future. Thank you.
Members, any other questions? Ms. Duran?
Thank you, Madam Chair. Thank you for bringing this bill forward. My question is, I know that some of the home health care workers do several different types of duties when they are hired. Are they paid based on, for example, I know it says personal assistance, is it cleaning or doing different duties, or is it just a flat rate that they get? Do we know?
So I'll add to that, but I'll let Ms. Lockhart. So when
presenters, I just want to remind you to identify yourself
for the record. It was hourly for when I paid, and the setup for me. And so you get a contract which lays out. So it had additional duties, like they could do laundry, they could wash dishes, they could sweep, they could bathe, they could do prescription reminders, not give the prescription, but it was very limited, meaning that work could only be for the patient or the patient area. So, for example, my dad, we got the benefit of one of his friends renovating this really big house, and so we were able to, she was only focused on one area of the house, nothing else that we did. Like, so if me and my daughter dirtied dishes, okay, she was not responsible for that, nor did we ever ask her to do that. We put her, although those are duties we could have asked for, we just kept it to, can you put his pajamas on? Can you bathe him? Can you sweep the area with the Swifter and just give us a moment, couple of hours of rest? And so that was it. But the contract typically spells out what those duties are, and you can't go beyond those things. No, you can't ask them to do more. They expect your house to be clean. You can't have a worker come into your house and you have all of these barriers. Like, it was important that the employer come in and make sure that the pathways were clear for the worker, that they weren't going to be stumbling over a bunch of, stuff as if you're some kind of hoarder and you have all this stuff hanging around, or else they would have been like, you have to clean. Well, the way I understood the contract, you would have had to clean all of that up, but you had to have enough space to move the patient in and out. We never asked her to help put him in a lift, even though she could have, but those were one of the things. But it was based on the skill set. And so the way that my relationship was, and what I understood, was if I had just had, there were different levels. And so I said exactly the skill sets that I needed. And so because we had a lift, but me and my daughter pretty much focused on the lift, or I became like the expert in lifting humans into a wheelchair, but I never really asked her for that, but she could have helped in that capacity.
And then we also have, oh, I'm sorry, Assemblymember Duran, do you have any follow-up? Go ahead.
So based on, and I know you said, I think if I corrected, that you basically stated you picked $22 an hour. Does that amount of money go to the healthcare worker for her duties, or is that part of just getting the agency to send somebody out?
So thank you, Senator Gina Neal, for the record. That's a good question. When we were offered that pay range, I wanted the pay to go directly to her. Now, whether or not there was something taken off the top, I never asked, but we had timesheets and we had her fill out just the same as if her employer came in and she filled in for her. So we knew that when we wrote the check, that was the amount that we wrote the check for. We wrote it for $22 an hour, and that's what we expected her to be paid for. And the reason why I did the top of the range was because I wanted someone with more skill, right? And I wanted someone who was going to come in and really assist. And number one, and I didn't know what they were getting themselves into, nor did I know what I was getting myself into, because that was my first contract. And so I wanted to make sure that, number one, they were paid well, and that they were paid for the couple of, well, really the 15 hours a week that they were coming in, that it was enough for them to be able to take care of themselves, and because they were coming into our space to help take care of my dad. But it was a range. But it was my understanding that that's what she received, and when we would get the invoices, it would reflect that amount. So I don't know what other PCA companies are doing. I just know the one that I work with, and I got the invoices every 2 weeks that showed what Miss Tina would get paid and versus the company. And I had to do an initial deposit too when we brought it on, just to make sure that there was a buffer to, if we didn't pay on time, to make sure that that worker was paid.
Thank you.
Assemblymember Dickman.
Thank you so much, Chair. And thank you to all the home health care workers. I would have to agree with Assemblywoman Tolles. They are doing God's work and they're God's angels. But I do just have a question about Section 20, Sub 2. Don't we already have compliance regulations in place? And what was the thinking behind adding this misdemeanor and up to $1,000 fine?
Through you to Assemblywoman Dickman, thank you for your question.
Miss, if you would just identify yourself.
I'm sorry, Marlene Lockard, Lockard. This is precisely why we need the board. There are some compliance regs in place. They are implemented sporadically. There is no consistency across the board among what employers implement right now. They're supposed to pay for training. There are some agencies that do not pay for training. And if there's some 300 employers in the state of Nevada, if we could develop standards and consistency through this board, as we were previously discussing, the wages, the average wage for a home care worker is $11 an hour. That's what they receive on average in the state of Nevada. So you can see some have the ability to earn more depending on the employer and that situation. So the enforcement piece is a piece that we also need to bring together for those compliance directives already in statute. So thank you for that question.
And Senator Dina Neal, I want to add to this because when you look at Section 20, Section 20 to me lays out employee protection. So when you read Section 20 sub 1, we're talking about discharge, discipline, and discrimination. And so if a person is, and then also it says threatening someone. So if we get into a situation where we're trying to establish worker protections where an employer is discriminating, threatening, or doing something that is a negative response to an employee, I think the penalty that you're addressing, Assemblywoman Dickman, in sub 2, violating that provision and being guilty of a misdemeanor and shall be punished by a fine of not more than $1,000 is actually minimal if we're talking about a discriminatory action or if we're talking about threatening. I also don't think that these provisions will just come in play without some kind of review or action, because I believe that my way I read this, these protections come under the Labor Commission, and that the Labor Commissioner will then do their review, should be a, hopefully an appeals process to then make sure that, number one, the facts are correct, that there was a threat, there was discrimination, and that it is fully vetted before this is triggered. But $1,000, I think, is minimal if somebody was to discriminate against you or to threaten you and you were an employee.
And I'm going to jump in really quick before I come to you for follow-up, Ms. Stickman, but did you say that the average home health care workers' earnings are $11 per hour? Is that what I heard?
Yes.
Well, I think we can all agree that God's work deserves more than that. Assemblymember Dickman, did you have any follow-up?
Actually, I do, if you don't mind, just quickly. So this applies to people who are employed, who are working in home health care, but employed by someone. There's a lot of people, aren't there, who do this on their own, who would just, find clients. How would this help them? Would it?
So that's a really good question, but I'm gonna answer Senator Dina Neal for the record. I'm gonna answer this in part, and then I'm gonna turn it over to Ms. Lockhart. So yes, there are opportunities for a, let's say, a sibling or whatever to get trained and then be paid, and then they would do that work for their family member. That was something that I found out in this process and in this journey because one of my family members were talking about, trying to get trained and then quit their job. And I was like, negative. We're going to stick with a trained professional and you're not going to go through the training because number one, because of what my expectations were for care, and I wanted somebody that was from an established company. But that option is there, but typically it is a person that who then goes in the training, or a family member who can then receive that. But in terms of how this would apply, they're employed by, to me, the division. But go ahead.
The healthcare employers are supposed to be licensed in the state of Nevada. Not all operators operating today are licensed. And so that's one of the provisions in this bill that would take a look and see which employers are currently doing this work without a license. So if one of our healthcare workers work for a licensed personal care agency, there are protocols and training required by the state that they must follow. If an individual is hired on a personal level, they are, to my knowledge, would not know or be subject to that training or the required protocols of a licensed home care employer.
Okay, thank you. Assemblymember Dickman, actually, I'm going to go ahead and see if there's any other members with questions because we need to keep the bill hearing moving. Remember, we still have
Good, thanks.
4 other bills on our agenda today. So at this time, I'm going to go to Assemblymember O'Neill.
Thank you, Chair. I'll try to make this really quick. If I understand correctly, you're saying we've got licensed healthcare providers and Health and Human Services, I forget which division it is, the quality assurance or something, isn't doing their job and overseeing them properly, that even the licensed, the employees of these agencies aren't being properly trained, provided with the necessary equipment and to do their job. So the state's falling down now. We should stick with the law we've got. I guess that's what I'm a little confused here. And then I have one follow-up question, if I may, very quickly.
Thank you, Assemblyman O'Neill. The state is, I'm Marlene Lockhart, representing SEIU 1107. The state has responsibilities of enforcing the statutes and regulations that currently exist. One of the problems, as I've stated, is the inconsistency across employers. And as I stated, some of these employers are operating but without a license. And so that's one of the reasons why we need a board, is to pull in, identify, and you read the bill, that's why there's an investigation to see what is out there, who is complying, who is not complying with current rules, and then the regulations that will be adopted as a result of some of these investigations. So hopefully that answers your question. Thank you.
So if I may, Chair, so I'm thinking of the contractors board that oversees, you can become a licensed contractor in the building trades. There are still people that work outside of that, and then it's a buyer beware operation. But what I'm hearing also is that those that are now being licensed aren't being held to the standard, is what I'm hearing. But the other question I have for time frame, is this proposal, the study, this board, to do a study and report back, or are they going to form up and they will now become the controlling force without further legislation?
No. The first, to answer the second part of your question, the problem is identifying those folks not complying. When you're unlicensed now, and if we do a survey, we can identify folks that are not in compliance. The second question that you had, the board will make recommendations to the Director of Hhs. He has the authority to implement some within his purview, his current authority, adopt regulations. Others, recommendations that would be subject to state or federal requirement would come to this body for approval. So it is not standing on its own, implementing a wage increase, for example, without review.
So Senator Dina Neal.
Thank you.
Okay,
I'm going to go ahead and go to Assemblymember Casamano.
Thank you, Chair. Thank you, presenters. I was just curious, under Section 20, number 2, where it has a home care employer who violates the provisions of subsection 1 is guilty of misdemeanor and shall be punished by a fine of not more than $1,000. I'm just wondering where you came up with that as far as a misdemeanor. I know we're trying to decriminalize so much during the session, and now this is a new board a new regulation, we're going right at it with a misdemeanor. So I'm just wondering what the thought was behind that.
At the present time, there is no motivation for an employer to follow some of the regulations and requirements that are on the books. This is an enforcement mechanism to protect the home health care worker. This is a fine on the employer.
And that was Marlene Lockhart for the record. And I just want to put it on the record, too. This is actually a really low fine because the Labor Commissioner's administrative fine authority goes up to $5,000 in her chapter. And so capping it at $1,000 is actually taking away some of the Labor Commissioner's authority that already exists in NRS.
Senator Dina Neal, for the record, thank you for that, Chairwoman, because I was just getting ready to say that there are different discrimination provisions that you can find if you go research, even under retaliation provisions, discrimination provisions under NERC, Labor Commissioner, where the fines are a little different. I've even seen bills that have come through and been voted on that have a much higher threshold. Bill that I think that we just heard, actually had one that was significantly greater. I think it was 10,000.
Perfect. Okay, at this time, seeing no further questions, I'm going to go ahead and move us into the testimony portion of the bill hearing. Members who are here to give testimony, I do again want to reiterate, we still have 4 bills on our agenda, so I will be enforcing the 2-minute time limit on testimony so that we can hear from as many people as possible. So if you are here in Carson City to testify in support, please make your way to the table.
Madam Chair, members of the committee, for the record, my name is Annette Magnus, and I'm the Executive Director of Battleborn Progress. We are here today in strong support of SB 340. Nevada's home health care workers are on the front lines of caring for people in this state. The importance of and demand for their dedicated labor has increased during the pandemic. We must treat this workforce with the respect and dignity that they deserve. Too many of the state's 13,000 home care workers are underpaid, exploited, and their working conditions have only worsened during the COVID-19 pandemic. Without oversight of working conditions, those home health care workers the people who they care for will be also at risk. Our home health care workers in Nevada deserve better for themselves and their families while they maintain the health and independence of tens of thousands of Nevadans. Please pass SB 340. Thank you.
Madam Chair and members of the committee, I am Brian Lee. I am the Executive Director of the Nevada State Education Association, the voice of Nevada educators and students for over 120 years. Previously, I worked as a home care worker and organizer. I have personally seen the impact home care workers have on the lives of their consumers, affording thousands of people the ability to live with dignity in their homes. I have also seen the detrimental effects that can be wrought by the lack of proper oversight over these essential programs. For the past 116 days, NSCA has advocated for educator voice in decisions that impact our work. But educator voice is only part of our larger goal of establishing true worker voice. SB 340 establishes a voice for home care workers, a vital group of workers who are too often overlooked. NSCA and I strongly support SB 340. Thank you.
Good afternoon. My name is Rosita Love, R-O-Z-E-T-T-A, L-O-V-E. I live in Las Vegas, Senate District 4, and I'm a constituent of Senator Dina Neal. I was born and raised here, and as I watched our city grow, I've seen the need for home care service keeps growing as well. I'm here today to ask you to pass SB 340 and create the home care standard board we need to investigate the issues facing home care workers like me and also our clients. We do this work because we care deeply about our clients, our community. Despite our vital work, we are paid poverty wages, and most of us do not even have health care or paid sick days. We deserve to be treated fairly, and our clients deserve the highest quality care. Right now, about half of home care workers leave their jobs in a year. It's essential work, but too many people can't make a living at it. My hope is that we reform the home care system and make home care jobs, good quality jobs with living wages, so that the next generation of workers can proudly take care of me and our loved ones. Thank you for listening and supporting S340. Thank you.
Thank you for your testimony and for being here.
Hello, my name is Shanika Cooper. That's SHANIEKA. Cooper, COOPER. I'm a long-term home care worker and a constituent in Las Vegas Assembly District 3. I'm speaking in support of SB 340 because home care is essential for the safety and well-being of seniors, and it also saves taxpayers money. We need to make sure we have high-quality home care systems here in Nevada, so home care workers like myself can provide decent lives for our families and our clients get the very best care. I started in home care years ago after caring for my great-aunt. During this time, I discovered a passion for helping and caring for others. Early on, I was shocked to find out home care workers have to pay for requirements to obtain a job here, like our fingerprints and basic training. This is a really burden if you don't have any income when applying for a job. Not only are home care workers struggling, but our clients are too. Because with the low wages and lack of benefits, it's very difficult for clients to keep and find quality home caregivers. With our aging population here in Nevada, this has become a major crisis. SB 340 will give workers like myself and consumers a seat at the table, along with employers and elected leaders, so that we can lift home care workers out of poverty and make sure seniors get care they deserve. Please pass this crucial bill. Thank you.
Thank you for your testimony and for being here.
Good afternoon. My name is Carol Matrone, CarolMatrone. I'm a longtime Las Vegas resident. I'm here today in support of SB 340. I'm here as a consumer. My daughter is 30 years old, significantly physically challenged and disabled, and has received home care worker services since the year 2000. So in addition to being here in support with my SCIU sisters, I'm also a longtime AFSCME member, as I was a state employee until November 2019. At that time, as a local long-term care ombudsman, serving seniors and vulnerable adults across our state, in Las Vegas, I had to prematurely retire due to back-to-back COVID scares and quarantines of my daughter and myself, often being the last caregiver standing. So at that time I retired and I became her home health care worker myself, receiving wages through a local long-term, a local health care company. But I'm really not here for myself. I'm really here for my daughter and the workers that I've seen come through our doors since the year 2000. I counted last night. I thought maybe I was embellishing my number, but it's probably close to 100 workers that come, get trained, form a relationship with my daughter, and move on because they can't stay in this position with a sustainable wage or working conditions. Then it often devastates my daughter, who is dependent on these workers for every aspect of her daily living activities. That's bathing, dressing, grooming, toileting, everything, getting up in her wheelchair, all of that. So I would appreciate your support of SB 340, not only for those home care workers, for my daughter, and for aging parents such as myself who've had to step up and become caregivers in this field. Thank you for your time.
Thank you, Chair and members of the committee. For the record, my name is Tess Opferman, speaking on behalf of the Nevada Women's Lobby. First, we want to thank Senator Neal for working on this bill and bringing forward such important legislation that will help families, seniors, women, and people of color. I know the statistics have been talked about, but I just want to focus on the fact that of the more than 13,000 home care workers in Nevada, 84% are women and 35% are women of color. This is significantly higher than the general population, where women of color make up only 17% of Nevada's total population. These workers make an average of $11.07 an hour, which is simply not a sustainable living wage. This leads to a high turnover rate in the home care industry, and caring, qualified workers are leaving the profession at a rapid pace. We have an entire workforce trained to care for our aging parents and grandparents, allowing our family members to stay in their houses and get the services they need, but we have to pay a living wage and ensure adequate training is in place. We urge your support on SB 340, and we thank you for your time this afternoon.
Thank you, Madam. Thank you, Madam Chair, members of the committee. For the record, Rusty McAllister, representing the 150,000 members of the Nevada State AFL-CIO. We're in support of this legislation for all the reasons that have been stated before. I'll just include a ditto, Madam Chair, and we are in support.
Good afternoon, committee. My name is Jim Sullivan, and I'm representing the Culinary Union. The Culinary Union supports SB 340 because we strongly believe that all workers should be treated with dignity and respect, and are proud to support home care workers who are organizing and have a voice on the job. Many home care workers are women of color who earn low wages and have no health care themselves, while they are providing essential health care for our loved ones, seniors, and individuals with disabilities. That needs to change. Home care workers were always essential, and the heroic risks these workers have faced to take care of Nevada's most vulnerable citizens over the past years has cemented this fact. The need for high-quality home care services in the Silver State is skyrocketing, but too many of the state's 13,000 home care workers are underpaid and exploited. To ensure that all Nevadans can age and retire with dignity, the state must have a well-compensated home care workforce with safe working conditions. We would like to echo the comments of SEIU and the other supporters of the bill, and also thank Senator Neal for bringing this bill forward. The Culinary Union urges the Nevada Legislature to support and pass SB 340. Thank you.
Good afternoon, Chair and members of the committee. For the record, my name is Christine Saunders, and I'm the Policy Director with Progressive Leadership Alliance in Nevada. Providing care for aging adults and people with disabilities isn't just a job. It's a deep commitment to work hard to support Nevadans and their families. These workers are entrusted to care for others, and we should ensure as a state that we take the best care of them by passing SB 340 and urge your support of this bill. Thank you.
Good afternoon, Madam Chair. Priscilla Maloney with the AFSCME 4041 retirees, for all the things that have been said, very important things this afternoon in support of SB 340. We are also here in solidarity to give our support. Thank you.
Thank you, Chair. Benjamin Challenor, Policy Director for Faith in Action Nevada. As was mentioned during the presentation and during the questioning, these workers are doing God's work. They're taking care of our loved ones, and we would like to echo the statements before, especially the home care workers that came up and spoke. Thank you.
Good afternoon, Madam Chair and members of the committee. For the record, Tom Dunn, representing professional firefighters in Nevada. Today, I sit here in support of SB 340. As a child who's grown up here in Nevada, I have two aging and disabled parents, and I encourage you to vote yes on SB 340. Thank you.
Kent Irvin, Nevada Faculty Alliance, ditto.
I appreciate the brevity, Mr. Irvin. Seeing no one else here in Carson City and no one on Zoom broadcasting, can we please go to the telephone, and we will take approximately 3 callers on the telephone so that we can move into our next portion.
Testify in support of Senate Bill 340. Please press star 9 now to take your place in the queue. Caller with the last 3 digits of 459. Please slowly state and spell your name for the record. You'll have 2 minutes and we begin.
Thank you, Chairwoman Sandra Hardicke and members of the committee. For the record, my name is Jerry Burton. It's Jeriburton, and I'm the president of the Nevada chapter of the National Organization for Women. and I'm here representing our members in support of SB 340. As you've heard, 84% of the home care workers are women and 35% women of color, and we have a shortage of home care workers in Nevada that's putting a huge burden on the workers who are required to work long hours and be on call for their clients. And we need to investigate the working conditions of the home health care workers and see they're paid a living wage, and this bill will give them a seat at the table. My sister is a home health care worker and is often called in the middle of the night to run to the aid of her clients, and families who often do not even live nearby rely on her care for them at all hours. And when the pandemic started, she didn't have the option to stay home. Her clients needed her, and she was given very little for PPE. She mostly provided her own. And my mother had a rare disease, primary progressive aphasia, and required around-the-clock care towards the end of her life. We had an amazing home health care workers helping us care for her, and they treated my mom like family. They deserve safe working conditions, better pay, and benefits, and we urge you to vote yes on SB 340. Thank you.
Broadcasting, next caller.
Caller with the last three digits of 111. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
My name is Eva Love, EVA, LOVE. And my husband had a bad stroke 6 years ago. And since then, we have had caregivers in our home helping to take care of him. And I know that many of the agencies that hire and send them out are running on a wing and a prayer. We've had a lot of different caregiver agencies over the years with a lot of different caregivers. And most of the agencies don't have professional staff. They don't have policies that support the caregivers, and they often treat the caregivers badly. For an example, the caregiver that we now have was being asked to work a 6 a.m. shift for another client before coming to us at 8 a.m. and then a 9:30 from 8 a.m. to 9:30. Then she comes back from 8:30 to 10:30, and she has to drive 45 minutes home. And then she was supposed to, get up at 4 o'clock in the morning to go back and start her 6 a.m. shift. So it just was completely unfair, and she had to. I finally talked to her and I said, this isn't right. Because she was afraid that if she said anything about it, that they would not give her any more hours. So the caregivers don't have any power with the agencies. And of course, this isn't the worst example, but you can see that if the caregivers had a seat at the table, they would feel like they wouldn't have to take the abuse that many of them take. I am in support of SB 340. Thank you.
Thank you. NBPS, we will take one more caller. And for those of you who are on the line but didn't get to testify, please, I encourage you to submit your written remarks, and we will include them in the meeting record.
Chair, there are no more callers in support at this time.
Okay, is there anyone in Carson City wishing to testify in opposition? Okay, is there anyone on Zoom in opposition? Okay, broadcasting, could we check the telephone line for opposition?
To testify in opposition of Senate Bill 340, please press star 9 now to take your place in the queue. Caller with the last three digits of 717. Please slowly state and spell your name for the record. You will have 2 minutes and may begin. You are unmuted, sir.
Hello?
Yes, you are unmuted.
I was waiting for my last numbers to be called. For the record, Madam Chairman, I'm Connie McMullen, representing the Personal Care Association of Nevada, which opposes SB 340 because creation of a labor board exceeds what is already in statute. SB 340 creates a board operating alongside the current regulatory role of the Division of Public and Behavioral Health, Division of Healthcare Quality and Compliance, and the Office of the Labor Commissioner. SB 340 asks the state to fund the board and expand HCQC and the Labor Commissioner's role to carry out investigations. To say the obvious, the responsibility is already in regulation, and suggesting a board facilitate investigation is implying the state is not doing its job. SB 340 will also give the board the ability to set a minimum wage. This requirement found in Section 18 raises concerns. Unless mistaken, it is the role of the legislature to recommend increasing the minimum wage and the governor to approve it. Why do we need what appears to be an aggressive approach to force what we already have the ability to do? SB 340 creates the board which will make recommendations, one that we believe will be a recommendation that caregivers working in Medicaid be unionized by the SEIU, the bill's main supporter. Nevada is a small state with limited tax dollars. It does not need a union making decisions how the state should provide care to the most vulnerable. PCAN is in favor of the legislature raising the personal care reimbursement to help support anticipated demographic growth as the state increases its minimum wage. PCAN does not support SB 340 because, in spite of good intent, it is a bad bill for business and for seniors. What I have heard today is fraught with little understanding in fact. Anyone who does state business has to be in compliance and licensed. Those do not get to use public funds, period. I thank you for listening to my remarks today, and if you have any questions, you can call me later. Thank you.
Broadcasting, next caller.
Chair, there are no more callers in opposition at this time.
Okay, thank you. Is there anyone wishing to testify in neutral in Carson City? Is there anyone expressing to give neutral testimony on Zoom? Okay, broadcasting, could we check the telephone line for neutral testimony?
To testify in neutral of Senate Bill 340, please press *9 now to take your place in the queue. Chair, there are no callers for neutral at this time.
Okay, thank you. At this time, Senator, did you want to give closing remarks? Okay, at this time, I will close the hearing on Senate Bill 340. Thank you. Thank you. Okay, members, for those who are here, just to give you the lay of the land, we had on our schedule 4 other bills. We will be hearing Senate Bill 325 next, and we will be rolling the following bills until our next meeting. So right this time, I will open the hearing on Senate Bill 325, which establishes provisions relating to preventing the acquisition of human immunodeficiency virus. Thank you, Senator. When you are ready, you can begin.
Thank you, Madam Chair and Committee of Commerce and Labor Assembly. A long time since I've been back in Commerce and Labor, served on this my first 2 sessions. Senator from District 17, representing all of Douglas, all of Carson, all of Lyon, all of Story County. Before you today, Senate Bill 325, as you indicated, deals with human immunodeficiency. What it really means to do, I'll try to make it Reader's Digest because I know you're all busy and have a lot of other things to get done. Expands access to the underserved communities and also to those that are at risk. We all know that this health crisis has showed us, without a doubt, that we do not have enough doctors out there to help individuals. What the bill seeks to do is allow pharmacists to kind of step in and help out, especially in the realm of dealing with pre-exposure to immunodeficiency and also to post-exposure. With that, though, there also are some amendments. I believe I sent the chair, and I hope that the committee was able to get the amendments, discuss the concepts that it's come to our attention. There are actually some new possibilities on the horizon to help out in this regard, and we just want to make sure that the language gets changed to be able to deal with that now. So in that respect, we're asking that the word administrator be administrator be inserted into the language throughout, and also on Section 7 deals with a concern I believe that the Culinary Board had, wanting to help make sure that reasonable medical management techniques are utilized, and also that prescription drugs to present the acquisition of those things are also included. So we tried to make sure the other outliers that were out there were included within the amendments to try to make sure that there theoretically is no more arguments. I had to swallow some things that we didn't necessarily want, but sometimes we have to do what's best overall policy. In that respect, it was very brief. If you wish, at this time, it probably would be best to go to Liz McMiniman, who I believe is on the line, who could go into more detail, or if you wish to go to questions now, that is your choice, Madam Chair.
Ms. McMiniman, did you have remarks to give? Oh, I believe you are on mute, Ms. McMiniman. Why don't we ping our BPS to maybe lend a hand? I know they've been able to solve this problem for us before.
Okay,
There
I
you
got it
go.
now, I think, Madam Chair. Madam Chair, for the record, Liz McMiniman, Retail Association in Nevada. I'm not going to keep you long. I think Senator Settlemeyer covered the major points. I just want to say thank you for hearing this afternoon, bringing this forward. This is a really important bill, and I have an overview of the bill if you want, or I will just remain quiet and let you move forward with any questions that the committee may have. It's at your discretion, Madam Chair, how you would like me to do this.
Why don't we go to questions? Members, questions for our presenters? Seeing that we have no questions, Ms. McMiniman, why don't we go ahead with your remarks?
Thank you very much, Madam Chair. Again, for the record, Liz McMiniman, Retail Association in Nevada. And as Senator Settlemeyer pointed out, SB 325 will effectively increase the access to prevention and treatment for contracting HIV. And it will allow the pharmacist to initiate, dispense, and administer these medications. HIV infections disproportionately affect certain minority populations, including the Black and the Latinx individuals. They represent 69% of all new HIV diagnoses in our HIV actually is estimated to have impacted 1.1 million people living in the United States, and 14%, or 1 in 7, are unaware that they are even infected. We want to make sure that we are able to reach those communities where healthcare is difficult to obtain, and a lot of times the pharmacy is the one place where people that a patient will feel more comfortable going into. It seems like some patients feel that pharmacies are less stigmatizing than the traditional HIV testing sites, and are therefore more comfortable with receiving testing and treatment at these facilities. Access in communities across Nevada and long trusted by patients, a pharmacy efficiently and safely provides critical health care services. Pharmacists and their staff stand ready to provide expanded, timely, and convenient access to HIV testing and prevention. This bill points out that the pharmacist has the ability to test. They have to test before implementing any type of prevention or treatment for these patients. HIV prevention medications are effective public health interventions. With PrEP, when taken daily, reduces the risk of getting HIV from sex by 99% and by 74% among those who inject drugs. So with that, I just ask that the committee look at this bill closely. I feel like it's an important piece of legislation in helping the community with the HIV issues, and I'd like to see these life-saving techniques brought forward in the state of Nevada. And I thank the committee and just urge your vote and support on this legislation.
Thank you,
Madam Chair.
And I know we said we had no questions, but I do have one clarifying one, Senator. So I'm looking at the bill, Section 7, Sub 4, and then I'm looking at the amendment, Section 7, Sub 4, and they appear to be identical. And so I wanted to make sure that wasn't an error, and maybe there was supposed to be an amendment, or if that was left over from the amendment on the Senate side. It looks like Section 7, Sub 4, where it says Section Sub B, any prescription, the word any was added in, and then there was the new language B, and they're exactly the same.
You are correct, as always, Madam Chair. Senator Sotomayor, for the record, it looks like it was just left over. I forgot to delete that out.
Okay, so that was just left over from the amendment on the Senate side. Okay, perfect. So then the only amendments being added are the earlier ones on this document, Section 1 and then Section 2.
Correct. The administrator section and administer and administration for the concept of the new stuff that's coming forward is in Section 1 and 2. And I believe the Section 10 has a change, though, that was indicated that was necessary, requested by culinary, I believe.
Correct, in Section 10. Okay. Members? Okay, seeing none, we will go ahead and move into the testimony portion of the bill hearing. Anyone in support in Carson City, please make your way to the table.
Good afternoon, Madam Chair, members of the committee, Bradley Mayer, BradleyMayer, partner at Argentum Partners, representing the Southern Nevada and Washoe County Health Districts today. We just wanted to support this bill, and it's it's an important bill in terms of getting these drugs to people. But we just want to also emphasize that the regulations that the Board of Pharmacy will adopt will make sure that they have the proper standard of care for administering these medications in regards to the labs and follow-up that are sometimes required. So just want to emphasize that, and thanks for your time.
Madam Chair, members of the committee, for the record, my name is Annette Magnus, and I'm the Executive Director of Battleborn Progress, and we are here today in proud support of SB 325. This bill will lift an incredible weight off our already strained healthcare system and help Nevadans with this critical issue. Pharmacies providing access to medications to prevent HIV in Nevada will be a relief for patients as well, since this will mean direct access to life-saving medication. We have been very consistent on this issue this session. Pharmacists should be able to prescribe these types of medications. This is basic health care. Please support this important bill. Thank you.
Good afternoon, Chair and members of the committee. For the record, my name is Christine Saunders, Policy Director with Progressive Leadership Alliance of Nevada, here in support of Senate Bill 325. Senate Bill 325 is an important public health measure that will increase access to HIV prevention, testing, and treatment, as well as help to reduce stigma around these services, and we urge your support. Thank you.
Okay, is there anyone on Zoom? Seeing none, broadcasting, can we go to the telephone line?
To testify in support of Senate Bill 325, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 069, please slowly state and spell your name for the record. You'll have 2 minutes and we begin.
Hello, my name is Andre Wade, ANDRE. WADE, State Director for Silver State Equality. We're a statewide LGBTQ civil rights organization here in Nevada. Good afternoon, Chair Hodeggy and Chair Carlton. We are very much in support of SB 325. This piece of legislation would be a huge game changer in the overall fight against HIV. Nevada has the highest rate of HIV west of the Mississippi, and this fits into the overall plan to end HIV by using testing as a core tool and using prevention as a core tool with PrEP and PEP. So please, we urge you to be in favor and pass this bill. Thank you very much.
Thank you for your testimony, Mr. Wade. Broadcasting, next caller.
Caller with the last 3 digits of 089, please slowly state and spell your name for the record. You will have 2 minutes and we begin.
Good afternoon, Madam Chair and members of the committee. For the record, my name is Bobette Bond, and can you hear me okay? I'm echoing.
Thank you. Broadcasting, next caller.
Yes, we are able to hear you, ma'am.
Oh, okay. Thank you. So HIV prevention, for the record, I'm Bobette Bond, Culinary Health Fund. HIV prevention is something that we actually dreamed about back in the AIDS epidemic that took hold of our nation in the 80s and the first half of the 90s. I was a graduate student in public health at that time. And when I moved to Nevada, my first program I got to work on at the health district was AIDS transmission education. Many of us still mourn people that we lost, and many more have died since then. And here we are, 30 years later. There's while there's still over 1 million people in our country that have HIV, new infections are declining, and programs like this that make drugs more accessible and prevention more accessible are great ideas and bring the state forward dramatically. So I appreciate the bill. We appreciate the efforts made by so many public and private healthcare workers and advocates to make HIV prevention a reality in our lives. And we greatly appreciate the work of the sponsor to ensure patients have appropriate access to prevention in this bill. So on behalf of the Culinary Health Fund, we support the bill and we appreciate the people that brought it to the table.
Thank you. Broadcasting, next caller.
Chair, there are no more callers in support at this time.
Thank you. Is there anyone in Carson City in opposition? Anyone on Zoom? Broadcasting, can we check the telephone line?
To testify in opposition of Senate Bill 325, please press star 9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Okay, is there anyone in Carson City in neutral? Thank you.
Thank you, Madam Chair, members of the committee. My name is Tom Clark. I'm here on behalf of the Nevada Association of Health Plans, testifying in neutral on Senate Bill 325. We did have some initial concerns with the original bill, but with the amendments, we're comfortable to come forward and state our neutral position and help to get these prescription drugs to this important community. Thank you, Madam Chair.
Thank you, Mr. Clark. Broadcasting, can we check the telephone line, seeing that there's no one on Zoom for neutral?
To testify in neutral on Senate Bill 325, please press star 9 now to take your place in the queue. Chair, there are no callers for neutral at this time.
Thank you. Would you like to give any closing remarks, Senator?
Thank you, Madam Chair and Committee of Commerce and Labor. I appreciate your time here today. If there are any questions or issues that you have, please don't hesitate to reach out to me. In that respect, though, I would be remiss, since this is my last session, to not say that you would definitely have the best policy analyst in the building.
I do. Thank you, Senator. I will now close the hearing on Senate Bill 325. And again, for those members who were here for the other 3 bills, I do have to adjourn to let my members go to the Education, Natural Resources, and Revenue Subcommittee. So we will resume our business tomorrow and hear the remaining bills then. So thank you, and I apologize for making you wait. At this time, the last agenda item that we have is public comment. Is there anyone in Carson City wishing to give public comment? Seeing no one in Carson City and no one on Zoom, broadcasting, can we go to the telephone line for public comment? I would like to remind the callers that public comment is limited to 2 minutes per caller.
To take your place in public comment, please press star 9 now to join the queue. Chair, the public line is open and working, but there are no callers for public comment at this time.
Thank you so much, broadcasting. Thank you, committee members, broadcasting, and committee staff for being able to pull this committee meeting together on such a short notice. I appreciate everyone. Members, we are adjourned, and we will see you tomorrow.